A small artisan bakery in Mumbai decides to launch a beautifully designed website to sell premium cookies, and they include a currency converter that shows prices in euros while offering shipping directly to Berlin and Paris. By doing this, they have just stepped across the digital border into the world of the General Data Protection Regulation, or GDPR. The regulation applies not just to companies based in Europe, but to anyone offering goods or services to individuals located in the European Union. In legal terms, this is about the targeting of data subjects. Simply put, if you are actively trying to get a customer in Europe to buy from you, you are playing by their rules. It doesn't matter if your office is in Mumbai or New York. If you are talking to the European market, you are covered by the GDPR. You have probably seen this at the office where someone thinks, we are not in Europe, so we can ignore this. But that is a dangerous mistake. If your website is translated into German, or if you take payments in euros, you are clearly indicating an intent to do business there. So, now that we have mastered the core concept that GDPR follows the customer, not the company, you might be wondering how we determine if our marketing efforts are targeting those customers. Well, that brings us right into our next step, which is the intent to target test. Imagine an e-commerce platform based in Delhi that has a massive global inventory. They don't have a specific European marketing plan, but they happen to ship globally if someone asks. One day, a customer in Madrid places an order. Does this mean the company is targeting the EU? Probably not. However, if that same company suddenly adds a shipping to Spain drop-down menu and starts running Facebook ads aimed at Madrid residents, the situation changes instantly. The GDPR looks for intention. The book definition talks about the targeting of data subjects in the Union, which basically means, are you trying to attract European eyes? We look for clues like using an EU language that isn't the primary language of your home country, or mentioning local European customer support phone numbers. It is like setting up a shop window. If you decorate it in a way that specifically appeals to someone walking down a street in Rome, you are targeting them. If you are just a generic shop that happens to sell to anyone who wanders in, that is a different story. So now that we mastered how to identify if our actions qualify as targeting, you might be wondering how we handle the technical data side of these transactions. Well, that brings us right into our next step, which is the role of monitoring behavior. A fitness app developer in Bangalore includes a feature that tracks the GPS location of users to suggest nearby running paths. If a user downloads this app in Amsterdam and the app tracks their daily commute or exercise route, the developer is now monitoring behavior under the GDPR. This is the second major way companies get pulled into the European scope. Even if you aren't selling them a physical cookie or a sweater, if you are tracking their habits, their location, or their online activity to build a profile, you are subject to the law. It is the digital equivalent of a shopkeeper following a customer around, noting down every shelf they stop at and how long they look at each item. When we talk about monitoring, we aren't just talking about malicious surveillance. We are talking about cookies, tracking pixels, and behavioral analytics. If your code is watching a European user to figure out what they like, you are now a data controller with responsibilities. So now that we have mastered the concept of monitoring as a trigger for compliance, you might be wondering how we distinguish between simple data usage and actual behavioral tracking. Well, that brings us right into our next step, which is the nuance of data processing activities. Think about a software startup in Hyderabad that provides a simple cloud-based tool for scheduling meetings. They don't care where their users are, they just want to provide a service. However, they use a sophisticated tracking script to see how long users stay on each page to improve the software. If a user from Warsaw logs in and uses that tool, the startup is technically processing that data. The GDPR defines processing as any operation performed on personal data, which is essentially anything you do with information that identifies a person. It is not enough to say, but we only use it for internal analytics. If you are processing the data of someone in the EU, you have to follow the GDPR's mandates on security, transparency, and consent. I have seen developers pull their hair out because they didn't realize that a simple improve our site script was actually a regulated data gathering activity. It is not about stopping your business, it is about knowing what your tools are doing under the hood. So now that we have mastered the reality of how even background processing keeps us under the GDPR umbrella, You might be wondering how we actually handle the documentation when we realize we are in scope. Well, that brings us right into our next step, which is the documentation of compliance. A financial services firm in Pune discovers they have several hundred clients who reside in France. They have to prove that they are protecting that data according to GDPR standards. They can't just promise they are doing it. They have to maintain records of processing activities. This is the paper trail that proves you are a responsible guardian of data. If an auditor walks into your office in Bangalore, they don't want to hear stories. They want to see the map of data. They want to see where the data comes from, why you have it, and who you share it with. Think of it as a house guest list. You need to know who is in your home, how long they are staying, and who they are talking to. If you can't show the list, you have failed the safety check. It is about being organized, clear, and ready to explain your logic at any given moment. You have probably seen projects that fail because they couldn't explain their data flow to a regulator. Don't let that be your project. So, now that we have mastered the necessity of keeping clear records, you might be wondering what happens when we use third-party vendors to help us manage this. Well, that brings us right into our next step, which is the responsibility of third-party processors. A company in Kolkata hires an email marketing service based in the United States to send out newsletters. If that newsletter goes to subscribers in the EU, the Kolkata company is the controller of the data and the US service is the processor. Under the GDPR, both parties have specific duties. You cannot just outsource your privacy problems. If you hire a vendor to handle your data, you are responsible for making sure they are also following the rules. It is like hiring a contractor to fix your roof. If they accidentally dump trash in your neighbor's yard, you are the one who has to answer to the authorities. You must have clear legal contracts, known as data processing agreements, that bind your vendors to the same high standards you are held to. You are the architect of your data ecosystem, and you must ensure that every single brick, even the ones you buy from someone else, is solid. We have covered the targeting, the monitoring, the processing, the records, and the vendor management. You now have the full scope of how the GDPR reaches out and touches businesses across the globe.